Hey, Gwilym, how are you? It's been an age since we've done one of these, mate.
I'm fine, thank you. I can't remember how to do it. What do we do?
Well, we get some guests on and we talk about stuff. It's not that difficult, is it?
Oh, okay, I can do that.
What have you
That's
been
fine.
doing since the last time we did a podcast? Can you remember when the last time we did a podcast
Well,
was?
no, when's the last time was it in a pub?
It was in
Possibly
a
the last
pub.
time.
Yeah, it was in a pub. And which is probably why you can't remember it.
Well, no, I
Because
remember it really well. I remember here we did three, didn't we?
we
And
did.
apparently the editing job on the last one was
The
really,
last one
really
was,
quite
was
significant.
quite difficult for poor old Fran to sort the editing out. So what have you been up to? Anything interesting? Because we're now fully out of lockdown and stuff like that, so we don't talk about COVID anymore.
Been to America?
You have, haven't you? Yeah.
Did the big tour of the States, which is great to be back on the road again. That's still a lot of it. I was thinking, oh, some of this I could have done by Zoom, but there were some moments which you had to be in the place, and some quite cool stuff, lots of cities and things. And yeah, I think baby Beth was born last time round, but she's now a full-scale 10-month-old proposition, which is fun.
10-month old. 10-month old. Yeah, wow, amazing. Yeah, I've been out. I went to Canada. I did a super gig in Canada, and the best thing for me about being out in the real world again is wearing shoes.
What?
Wearing shoes, because I have an extensive collection of shoes, and it's just
yes, I do.
It's just so nice to be out in the real world wearing shoes again.
How was it? Where were you in Canada?
Where was I? I was in Whistler.
Nice.
Yeah,
No
exactly.
shoes.
So, well, you say that. So the interesting thing about being in Whistler was I went not dressed as I am now, which I know the listeners can't see, which is in a rather luxurious Santa fleece. But I did go prepared for extreme cold, which is what I was warned to do. So lugged this big suitcase full of all kind of padded clothes and the like to get there, and it was 23 degrees for the whole week that I was there. And there were lots of snow people running around trying to work out where they got snow machines from, because it was not the normal weather. Although I think it's now improved, if that's the right word for them now, in that it's got colder and it's snowing.
And so, and the listeners loving to hear about you and me. They really care more about the tortoise.
Yeah, so the tortoise is would be in his normal hibernation place, which is a fully insulated double box in the shed. But I was slightly, and it's got an internal thermometer that's connected to an external dial, so I can keep an eye on his temperature. It's a beautiful piece of engineering.
Hang on, is the thermometer internal to the box or to the tortoise?
The thermometer's inside the box, which is where the tortoise is. The dial is outside of the box because the tortoise is asleep and can't see the dial.
Because I'd struggle to sleep otherwise with one of those in there.
Absolutely right. Yeah. But I went down there just as the cold spell was starting to bite and thought it's getting a little bit close to kind of 2 or 3 degrees in there. So he's now in the conservatory in his box in a fridge.
You're tampering with the laws of nature here, Lee.
He loves it. Well, he doesn't love it. He doesn't know anything about it, obviously.
Lee Davis and Gwilym Roberts are the Two IPs In A Pod, and you are listening to a podcast on intellectual property, brought to you by the Chartered Institute of Patent Attorneys.
Should we crack on with the podcast, mate?
Go on then.
Yeah. So good one today. We've got a real posse in. This is our largest ensemble troupe, which is going to be a bit difficult to control, I know. And also it's in an area, I think, kind of like the sexy area of IP for me, which I know not enough about. So I'm really, really sort of keen today to delve into the depths of designs, which is something we've not done on the podcast before, and which to my mind is a great shame and something that I think is long overdue. So it's great to welcome in order and going first to newly elected SEPA Council member and designs guru, Weal Burrell. Will, welcome to the podcast.
Oh, thanks, Lee. Lovely to be here. And thank you for having us. I think we reached out, was it back in August? I think I followed you thinking, it might be nice to do one on designs, because we've done podcasts on all sorts of different things. And I thought, designs might be a sort of go-to area. So a little bit about me. Yeah, I'm now newly appointed to council, so looking forward to that next year. But I also sit on the designs committee of SEPA 2. So started out as a trainee back in 2010 as a patent trainee, and then sort of went through and kind of grew up with someone who also had a bit of an exposure to designs. And that's sort of really where I got my exposure and interest to it. And then really, since qualification, just really loved getting involved with the designs angle. So here I am today. So
yeah, you seem far too lively and energetic to be a patent attorney. Designs is your thing, isn't it? It's got to be. So sorry, that's no offence to any patent attorneys out there, obviously, and not
all here, literally here.
Who shall I introduce next? Emily, welcome to the podcast. Tell us a little bit about yourself, Emily Weal.
Thank you very much. Yes, I'm currently joining you from my maternity leave. In fact, this is one of my keeping in touch days, so it's great to be able to drop in, say hello to everybody, and talk about designs. Great idea for a podcast episode, because a few of us like to get really stuck into this subject, but not everybody gets much exposure to it. So it's really nice to have a chat and meet some fellow design enthusiasts. But I'm at Kelty, and I started training in 2011, so just shortly after Will. My main area of practice is patents in engineering and material science, but I do quite a bit of design work as well. Also sort of fell into it by accident, really, by sort of luck of circumstance, when I started working on various clients that needed quite a lot of design support, and quite early on was a big part of making Kelty's design practice a success. So that's me.
So you've obviously had a baby. What a flavour.
Yes, little Charlie, who is a boy. I know Charlie could also be a girl.
Yeah.
Is next door with Daddy for the next hour, enjoying some playtime.
I mean, I can do the baby talk, Lee. I've got how old is Charlie?
Charlie is almost 6 months old.
That's nice.
I've got older grandchildren.
This is my kind of closing weeks of maternity leave, actually, because I'm back in January and Dad takes over for 6 months.
Was that shared parental?
That'll be fun.
Oh, lovely.
Yeah,
brilliant.
exactly.
Good for Kelton.
Yeah, we're splitting it down the middle, which will be fun.
So in order only of screen for me, John Coldham, introduce yourself to the podcast. Hi.
Hello, thank you. Yes, nice to meet you all. Obviously, I know lots of people on the podcast already. So my name's John Coldham. I'm a partner at Gowling WLG. I'm head of brands and designs. I suppose I've been banging on about designs for forever, it feels like. I trained a little bit earlier than some of the other people on the call. I'm not going to say how long. And so I cut my teeth on some design based with Dyson, a big client of ours, and since then have done designs cases for all sorts of people, from small startups through to large companies. And it's fun seeing how these things turn out in the wash. And one of the things I've always banged on about is the importance of filing these things well. Now, we don't do filing at Gowling, but we do litigate them, and lots of the ones that come to us aren't that great. So I suppose I've been lobbying everybody to do better designs filings, which is one of the reasons I'm here now. But with good filings, you can get a lot of success with designs. And I think some people, sometimes designs get a bad rep as to how they turn out, partly because maybe rubbish in, rubbish out. But we can explore that in a bit.
I'm thinking there's got to be a super webinar in this about rubbish in, rubbish out on designs. I think we need to follow this up. Speaking of which, another designs guru, super designs guru, Matt Ridley. Matt, welcome to the podcast. Introduce yourself.
Hello, thank you very much for having me on. So I'm a patent attorney at Thorpe Tennant. I've done lots of designs work over the years, because I think probably the same as Emily and Will is, if you show an interest in a firm in designs and you do a bit of them, everyone starts giving you all of them, and so suddenly you become an expert without necessarily going out and seeking it. And I'm also now chair of the SEPA Designs and Copyright Committee, and so involved in sort of speaking to the UK IPO about designs in the UK.
Well, you're all really welcome. This is the kickstart to a new season for us, so we've got to make it a really, really good one. The podcast came out for a couple of reasons. First of all, and we've already spoken about this, I was really keen to do a designs focused one, because it wasn't something that we had looked at previously, and arguably doesn't have the profile within SEPA that it should. But now Matt's steering the designs and copyright committee, and we've got Will on council. All of this is going to change. And also, Will put something on LinkedIn that sparked my interest. Not hugely relevant for what we're going to talk about today, but maybe we'll weave it in at some point. Well, it was a post about social media and how it was important to devise and protect your online presence right from day one, right from the outset. And it was focused on online identity. So for me, I guess that's kind of like my Twitter handle and stuff like that, and how it's important to have consistency across social platforms. And I found all of that stuff really, really fascinating. So that for me was a was a spark for dragging you all along today, but I recognise that that's just a small part of the piece and not something that we'll probably talk a huge amount about. You all very kindly thought this through and popped some ideas in an email to me. I'm not going to ignore those, but I'm not going to start there if that's okay. So you're now all scared because we're immediately off-piste. And I'm going to start at sort of relatively kind of basic first principles, because we obviously have a SEPA audience listening to this, but we know that we have an audience from outside of SEPA, people who are generally interested in IP and the like. So can we have a really, really basic kind of first question? What's the design and how does it differ from other forms of IP? You guys have already mentioned patents, for example. Whoever wants it, really.
Maybe. Well, happy to pick it up. So I guess it's sort of one of the cornerstones of different intellectual property rights that we have. So we have patents, which you've spoken about already, which are very much for protecting inventions. So if you've come up with some sort of new way of doing things that results in a sort of technical benefit, that's the area of patents. And then you've got at the other end of the spectrum, you've got trademarks, which is very much sort of brand focused. So if you've come up with some sort of like decent branding, like Coca-Cola or something like that, or a logo, then you've got trademarks to present that. And then you've got this designs, which I think sort of sits in the middle, really. So if you like appearance, anything appearance, that is really then in the remit of designs. And that can be the appearance of a tangible product, so something 3D, or it could be a graphical user interface, so maybe something on your iPhone if you've got a new app. And even other things we can maybe get onto, sort of like surface decoration as well. So sort of a tube maquette or something like that. That would be also in the realms of design. A tube maquette. So for instance, if you went on the London Underground, you all sit on the London Underground seat, they have the really funky patterns, which are one on each line. You can get design protection for those sorts of things as well. So it's such a broad area. And I think, and I'm happy to hear what the others think too, but I think it's just, a lot of people don't know too much about it, so it's just one of these things that can get overlooked. But happy for anyone else to chime in as well on their thoughts too.
Yes, that's a great summary. Well, yeah, all about the aesthetic basically. And I think the one thing to keep in mind for somebody who's not necessarily familiar with these sorts of rights yet is that almost every physical product that somebody comes up with is going to have all of these rights overlapping in them. So there will probably be some patent protection that could be obtained, and there will probably be some design rights that are either arising automatically or that could be obtained for the product. And that could be in all sorts of different aspects at the same time. So it could be for the physical form of something, like Will said, the surface pattern on something, and you might have different aspects that could have different design protection. So think of something simple like a chair. You could have a particular design feature in the shape of the legs and a particular design feature in the shape of the back, and those could be separate design protection that you could go after and obtain.
Cool. Matt, you got anything to add? Oh, Matt's shaking his head, which is never a good thing on a podcast.
First rule of podcast, just say something.
Yeah.
I might just add that there are different types of design even within designs, and I appreciate this could get complicated quickly, but it's important to realize that lots of design rights and design protection is just automatic, very unlike patents where you have to register them and there's a whole process to go through. So many design rights, you just have them, whether you want them or not. There are different rules about qualification, which I can expand on later if anybody wants to. But there's two sort of separate types of design. There's registered designs and all the details and differences with those, but there's also different types of unregistered design which come up automatically in certain circumstances.
So that was going to be my next question, John. So you're obviously well on top of the brief. My next question was: can you explain the difference between registered and unregistered design rights?
Well, shall I carry on? I'm not writing files of designs here, but the others on the call can explain how you file them in due course. But there's registered designs are what they say on the tin. In Europe and the UK, you file them at the registry, and they're not like patents. They are a completely different thing. And I'll let my colleagues on the call explain how you file those in due course. But unregistered designs are a bit like copyright, I suppose. You create a work and you get rights in it. The way you get the rights depends on what it is and who you are, which is a bit odd. There's lots of different types, and Brexit has made things even more complicated. There you go. I've said Brexit first on this. I'm sure we'll get there, but I've broken up.
So I've got that coming up as well, funny enough.
But the sort of UK design right, the one we've always had in the UK, even before the Europeans got involved, is quite a good right. It lasts 10 years and it protects shape only. And it protects products. It's something that's born out of copyright originally back in the 80s, but now it protects shapes of things. And it's a very, very powerful and very effective right that we can talk about later. But you only get it if you are British, or you live in the Caribbean, quite nice, or I think New Zealand or Hong Kong. So there's random places we have reciprocal protection. It used to be the Europeans as well, but as of the beginning of 2021, the European designers no longer automatically qualify for that type of protection. But it's still for anything created before that, it still works. But for British designers, it's still a very, very effective thing. The only other way of getting that, and that also plays into the European version of unregistered designs, is to market the product first in the UK. So if you want the UK equivalent of European unregistered designs, then first marketing in the UK is the answer with that as well. That gets quite complicated, so I'll stop there. But that's the difference. So you get unregistered designs, but you can litigate both at once. You can use your registered designs and your unregistered designs because they might protect slightly different things. And there are pros and cons, which I can take you through later. But that's to answer your basic question of what the difference is.
Yeah, perfect.
Yeah, I would say one of the reasons why sort of this questions after John is I know unregistered design rights can be extremely powerful, and I've seen them in use, and they're during enforcement, and they're very good. So the question is, why would you bother registering a design anyway? Because it costs money to do. Well, the sort of I think there are two real key things. Firstly, if you would want to enforce an unregistered design right, you have to prove that the other or the person who infringing actually copied your design. You have to prove that they copied it. And John can expand further, but I understand in a lot of cases this can be quite simple because, for example, if their product is identical to yours, it's pretty obvious that they did copy it, or otherwise you might have evidence that they copied it. But whereas with registered designs, you don't need to prove copying at all. You can enforce your registered design against someone who has no idea that your product even exists and has no idea that your registered design even exists. And then in addition to that, a registered design, it gives you a date and a very clear definition of what you have designed, because with unregistered rights, you might need to prove that they actually exist, as John alluded to, and proving, who you are, are you a British subject and everything like that, and when it was created and when it was first marketed, which can be fairly complicated. Whereas with registered designs, you don't need to do any of that. You just need to get it on file and you've got the filing date, and that's that.
That makes perfect sense to me.
I was just going to add that they also registered designs last 25 years if you renew them. So obviously that's a lot longer than unregistered designs. But, well, that's what I was going to say.
And also, I've just realised the other key point. Key point is that if you're not British and therefore the unregistered rights don't apply to you, the only design protection you'll get in the UK is if you register it. Will.
And I suppose the big thing with registered rights, and maybe, I don't know, from my perspective, it's one of the biggest take homes, and it's what people, they come to us and they say, oh, that sounds great. I want to register my design. Can I do it? One of the things is you have to register your design early. So what you can't do is come up with something, put it on the market for 5 years, and then go, okay, now I want to get a design registration, because by then it's too late. So it's a little bit like patents, but I'll be careful what I say. I'll sort of caveat this in a bit. But ideally, if you want to get design registration protection, you should get it as early on as you can, and preferably before you put it on the market, because after you put it on the market, it gets a little bit more complicated as to how you can get design registration protection. So think early and reach out early. It is probably one of the biggest take homes.
Yeah, it's a really good point, Will, because I think I've seen lots of circumstances where somebody's got a great product, they've got it out there, and it's only when they start to see infringement and people copying that they then think, right, what can we do? How can we protect this? And of course, if you're up to a year down the line, it's going to be too late at that point. So preempt it, get in there early with your registered design protection. Don't wait until it becomes a problem for you.
Can I just jump in? Because I know I'm not the expert you guys are, but I do a little bit. And my understanding is the timing's quite tricky though, isn't it? Because I'm sure we'll get on to the protection around a design is that much more limited. It's pretty close to, and you sort of forgive me for just demolishing years of jurisprudence. It's pretty close to what it actually looks like. So you got to be too early because you need to know what your product's actually going to look like on the market. You can't kind of do not like a patent application where you're maybe years away from actually rendering it down to practice. Is that right?
That is right. Obviously, one of the criticisms of registered designs when you come to read the cases on them is that they rarely are successful at court. And the reason for that is they are seen as very narrow. So if actually your product you make them after you've filed a registration is slightly different, and then they copy the actual product rather than the registration, then it may be your registration is too far away to catch the infringement that you're seeing in real life. And that's why I was talking earlier about how the best designs strategies involve a combination of registered designs and unregistered designs. Clever filing of registered designs to protect parts of articles rather than just the whole thing, combined with the unregistered designs, which you can formulate when you're actually issuing your proceedings in terms of exactly how you define them, which of course you can then focus on the bits where the similarities are, if of course they are key features of the product. So I think the two together are important, but you're right, there's a bit of a chicken and egg as to when you press the button on the designs filing. So you don't want to file a series of slightly changed designs consecutively. You can do them at the same time, but not consecutively, because each one could be used to interpret the one before it slightly more narrowly. And I have seen that at the sharp end at trial.
But I think you're exactly right, Gwilym. Also, I was just going to say that I think when you're doing design registrations, when people come to us and say they've got a product that they want protecting, one of the things that we try to do for them is to try and broaden the design protection net as broadly as we can. And it brings us actually onto one of the best things of the UK design registry, which I think is one of the best design registries in this respect, is that it allows you to put in lots of designs of different scopes all in one application really, really cost effectively. So to put it in context, if you have one design, the official fee is £50, whereas if you have 50 designs, the official fee is £150. So that's £3 for a design. So what that then means is that if you have lots of designs, you get lots of different bites at the cherry of making lots of different designs, which means that from a competitor's perspective, suddenly they don't just have to get around one, they have to get around lots and lots and lots, which makes their life that much more challenging.
Yeah, I sort of like to think of a bit of an analogy with patents in that a patent application or granted patent will have lots and lots of different claims that tend to start broad and then get narrow. And maybe for your initial patent application, you might even have some cheeky claims that are to some completely different aspects of the invention that you're never going to get granted, but you'll put them in there so you've got the possibility for a divisional later. Whereas with a design application, each design can only set out one scope. You can only have one sort of pinpoint on the spectrum of possible protection you could have. So I like to think of the various different designs you might include as being almost like different patent claims. You might have some that are broader, you might have some that shrink down narrower, you might have some that are directed to some completely different part, like the legs of the chair rather than the back of the chair, for example. And you can pinpoint your protection at all these different points in the spectrum, so you can really try and tie somebody in knots if they want to rip you off.
So to help me understand this as the layperson in the room, and not using an example that could easily be identified, I'll modify this as I'm going along to protect the innocent. If I was the designer of a wheel-along suitcase and that suitcase was in the shape of maybe the Tower of London, I would be well advised to not just do a design in the shape of the Tower of London, but maybe to also do Big Ben and Buckingham Palace, the London Eye and so on. Would that be true?
I mean, I think filing. Don't forget, unlike trademarks, you don't have to use your own filing. So take an example of a company that has done something similar to this, that is slightly different to the topic that you've just mentioned. There was a quite well-known case that Apple brought against Samsung about what was called the iPad design, but it wasn't actually the iPad design. What Apple had done very cleverly, and I can say that because I didn't advise them, was they filed lots of different thicknesses. Well, this is anecdotally, this is what they did. They filed lots of different thicknesses of iPad or tablets design. This is when the iPads they weren't a thing yet. This is back with the first iPad designs. They had lots of patents around the technology inside the iPad tablet so that it could make it miniature and thin enough. They knew, therefore, that lots of their competitors would not be able to make one that was as thin as the Apple one. So they filed designs for thicker ones to catch other people's designs. Now, whether or not you think that's right and whether or not they got away with it, because obviously Samsung succeeded in the action there, it is another story. But the approach is one that is good to consider. So going to what Emily said, you could have one for a shoe, which is the whole shoe, but you can get it down. And I've actually done a case about one of these in another country where actually it went down to the precise shape of the ridge in the underside of the sole. Because what the infringer had done is if you imagine the chevrons pointing towards the center of the sole, the infringer had inverted them. So the chevrons were pointing outwards. But each chevron, with all its quite intricate design work, was the same. It's just they turned it around. So if you look at the sole as a whole, they were opposite. I mean, they were pointing different directions. So did they have the same overall impression? Probably not. But when you look at one single chevron, yes, it did. And that's actually what caused the design to be changed by the infringer.
You can get down to real levels of detail, especially something like shoes, footwear, where there's such a dense design corpus out there that these little details become really, really important. And Lee, in your example there of your wheel on suitcases in the shape of various London landmarks, another approach you might take is to say, well, if it's particularly striking how the wheels are incorporated into the suitcase, if that's a really interesting design feature that's common to all of your various London landmark suitcases, then a design registration that is just capturing how the wheels look, because that's something consistent across the whole collection, could be a really useful right to have in place.
And I'm not going to leave John's point about Samsung and Apple without. We've had Sir Colin Burse on the podcast really early on. So Colin was a great guest, and I know he listens. So I know you're out there, Colin. Thank you very much for listening. It would be unforgivable to not mention that it was, of course, a landmark ruling. The first time that the word "cool" had ever been used in a UK judgment, when I think Sir Colin didn't he determine that the Samsung tablet wasn't as cool as an iPad.
Correct.
Actually, and also,
because
I've got quite an important question, Lee. The suitcase case that you referred to was actually for sit-on suitcases, as I recall. So my question to you is, which London landmark would you most like to sit on?
Not the
obviously the Shard.
The Gherkin.
But so the case you're talking about is the Trunky case, which has informed a lot of design filings since the Supreme Court decided on it. And actually, one of the things we haven't really talked about is how you represent your design in a design application. Because what lots of lay people do if they're filing their own design applications, they'll just take a picture of their product and submit that picture, and that's that. When they do that, they may not realise that if you say submit your wheel on suitcase with Big Ben on in green for some reason, your protection will only cover it in green, because that's the color in the design registration. So what you could also do then is file it in red and yellow and purple and everything like that. So you get those extra designs in different colors. But the best approach almost always is to file what we call line drawings. And so those are a bit like engineers' drawings, where all they do is they just have lines to show the shape of Big Ben with the wheels underneath it. And that will capture any color, so that it will capture the use of that shape in any color. And what actually Trunky sort of Chunky was very specific because it was about how they used what we call a rendered CAD image. And so it's if you create your design on a computer, you'll use some sort of CAD software, and using that software you can render it, so you put shading on it. And a particular issue there was that the wheels were dark. I think it was the wheels were dark and the body of the suitcase was light, and they interpreted that to mean that you'd have darker wheels than as compared to the body of it, because the shading was darker. And so in that case, it would have been much better if it had just been line drawings, because then it would have covered any colour, and that would never have been an issue. But often, if you have the budget, the best approach is to basically file everything you possibly can. So line drawings, rendered CAD images, photographs, all of the different colours, every single possible idea that you ever had for what it would look like, every single London landmark that you may or may not want to sit on, you file for every single one in all of the colours and all the permutations. Because if it costs you 150 quid for 50 of them, and then you have to litigate them, it's much better to spend £150. It would be much, much cheaper to do that than it will be if you only have one design and then you have to try and enforce that, which you may or may not win.
In which case, I'm now adding Nelson's
Yes.
column in immediately. This is great. I mean, we did have not a script, but you guys did send through some ideas of things we might talk about. I'm conscious that we've gone nowhere near it, but also that we've got quite a lot out of that. So I've just been reminding myself of the things that we said that we would talk about, and we seem to be, I think, talking around design registration and other related rights. And we've talked a bit about the UK process in this. So is there, to bring it back to the sort of script, if you like, is there anything about the UK application process that you particularly want to get across, perhaps how it differs from EU, if it does indeed?
I suppose really from the UK side of things, one of the broadest things that we have the potential for is to pursue lots of designs in one application, and they can relate to completely unrelated things. And I think that's one of the subtleties of the UK that you don't perhaps get everywhere else. So if you want to sort of have lots of designs in one application in other jurisdictions around the world, it's not quite so easy to do that. So this ability to bundle lots into one application, it's just not, you don't get the same cost saving. So I think that's one of the good things, but perhaps one of the, well, it can be a good and a bad thing. One of the areas of interest at the minute is whether the register is up to date with designs which are valid, because one of the things that we have at the minute is that you apply for a design, and usually to have that design, well, for that design to be valid, it has to basically be novel and have individual character. Now, what that basically means is no one else, your design can't look sufficiently similar to something that came before. Now, because the official fees are so cheap, the UK Design Registry doesn't do this assessment when you apply for a design. So it just takes it on face value that your designs are all okay in that respect, with the idea being, and probably John can allude to this, that if your design then ever gets enforced, these sorts of issues about whether it's valid or not start to come to light. So one of the issues that people can have is that you can then have, with a design registration, which is noted on the register, but that isn't necessarily an indication as to whether or not it's actually a good registration, i.e. whether it should be on the register because it's novel. So that's maybe one of the things that people are murmuring about, whether something needs to be done about that.
Yeah, it's a very tricky balance to strike, I think, because, like you said, the fact that it's so relatively simple to register a design, much simpler than registering a patent, for example, is great. You can go out there, you can get that registered right, but it is a little bit open to abuse, sometimes deliberate abuse, sometimes just an accidental circumstance where somebody's got a registered design that's maybe claimed a bit more broadly than is reasonable and it's actually not valid. But I've encountered situations where somebody's had a registered design that they know full well is not valid, and they're sort of waving it around and causing a lot of problems for somebody else, completely unfairly. But the system does have a sort of potential problem in that it can allow that to happen. But on the other side of things, searching for designs, that is hard. I do a lot of design clearance work in particular, and it is quite a challenge to work out how to really do a good novelty search for a design. So how do you go about setting up a system that allows you to do that searching in a way that's cost effective for the IPO to do it, actually meaningful? Because if you're going to go through that process, you want a decent result and to know whether something's really novel and valid at the end of it. That it's definitely a challenge, I think, that we face, and whether we go down that route or not is going to need some thought and some planning.
Well, I know that the UK IPO, they recently had a consultation, was it in July, which could be really exciting, because this is where earlier in the year they basically canvassed everyone, and they said that this is the current state of play with designs. What works for you, what doesn't? And this was one of the areas that they picked up. So we had, was it a consultation outcome? Was it in July?
There was a call for
Something
views
like that.
in July, but unfortunately, well, no, sorry, I don't know how we describe it, but because of the retained EU law bill, the UK IPO has had to delay the consultation for about a year. But one of the key things they were talking about doing was examining or providing some sort of examination of registered designs. But I think also I can probably go one step further than what Emily said, because I know that the UK IPO is aware of this, and the SEPA Designs and Copyright Committee is very well aware of this. But there is a big problem at the moment in the UK with people abusing the use of registered designs, because you can get a registered design for anything. I could take a picture of this registered design of the picture of the chair I'm sitting on and file a registered design, and then I could go onto an online marketplace and take down everyone and use that registered design in a takedown notice to take down the chair that I've just bought off Amazon. I'm not sure it's quite as extreme as that, but I've certainly seen instances, and I know other members of the committee and other SEPA members have all seen this, where people are heavily abusing the system in that way. And I know the UK IPO are also aware of it and they want to sort it out, but it's just a bit unfortunate that the consultation that could have sorted this out has been delayed by a year.
I've certainly seen it. I've been on both sides of these. I had to get somebody out of some trouble when they did just this, not on my advice, and they were then being sued for threats. There are lots of different ways of dealing with this issue. What I think practitioners are worried about, and something we've certainly discussed on the SEPA Designs Committee, is throwing the baby out with the bathwater. So we've got this issue that some people are abusing the process of designs because you can file anything, even if it's a long-standing existing design. And eventually they will be removed. You can get it invalidated, but it takes time. And in the meantime, they're using it against you. But there's also a great attraction of the UK and by extension the EU system, which works in a similar way, that it's very quick and efficient, which encourages people to register designs. We're trying to lobby people to register designs because they can be very effective, and to file lots of variants, which is all perfectly legitimate behavior, as we've been discussing on this. In fact, it's a good strategy that was recommended by the Supreme Court in the Trunky case, in not quite in terms, but pretty much. So to get rid of that with something making it much more expensive and slower as a result of dealing with the bad apples does have disadvantages. So it is not obvious what the right answer is. It could be, for example, to just increase the sanctions against people who do misuse the system, or have, a bit like the ASA has in advertising law, a system whereby if you're known to have abused the system, you have to have checks on your designs. Or, there's a million ways of dealing with this, and it'd be lovely to see what the UK IPO comes up with. And I know many stakeholder committees are helping the UK IPO, including SEPAs, to work out the best answer. But there isn't an obvious right answer that stands apart from the others.
Can I develop this a wee bit? Because Gwilym and I have been talking in the chat. You just keep stealing my questions in advance. And so
it's my fault, Tom.
No. It was Matt this time that did it. But so SEPA was involved, still is involved, but at the moment there's a little bit of a sort of a pause in it in IP pro bono. And IP pro bono was set up largely because Judge Hakon, IPEC, was concerned that there were a significant number of litigants in person who were getting themselves into all sorts of difficulties trying to represent themselves. And wouldn't it be good if the IP professions provided some kind of pro bono assistance there? By far, the largest number of applicants were not not people who were the victims of takedowns, although we could clearly see that coming through the system. It was perhaps the other piece you get yourself into when you're selling in that way. So small businesses, micro businesses, individuals, sort of couple working together who had been through the let's get a registered design and all of that side of things, were selling in places like Amazon, Facebook Marketplace, other online spaces, but finding they were being copied and finding that they didn't necessarily have the wherewithal or the resources to do anything about it. So what advice would you give to people who are in that position, who are legitimate businesses, they've got a product, but the product's being copied?
That's so one for me, doesn't it? The thing is, it depends on so many factors. I mean, doing takedowns is very effective. If you've been copied and the product is all over various platforms, if you can get the product taken off the major platforms such as Amazon and eBay and Alibaba, for instance, that will get rid of the majority of your problem. Especially if you've got a lower budget, that is a cost-effective way of doing it. There are risks in doing takedowns that shouldn't be, I think, it's beyond the scope of this podcast, but the groundless threats is something you need to be alive to. So obviously I would say this, but you should always be taking legal advice on doing some form of branding or design enforcement program, even if it's just to give you some pointers before you go and do the first bits yourself. And then, of course, it's worth bearing in mind that there are lots and lots of cases. You don't see that many designs cases coming through to court, and those that do, you say, the Court of Appeals, I think, heard 5 in the last 10 years or something like that, and they've all been unsuccessful. All the registered design owners have lost on registered designs. They may have won on unregistered designs, but they've lost on registered designs. So there's danger of following through to say, it's expensive and there's no point because I'm going to lose. What that misses is the fact that lots and lots of designs cases settle, and actually in particular registered design cases, because there's less to debate. It is I think it was Lord Justice Jacob, I can't remember if that's what he was at the time, who said that you should be able to decide a designs case within a matter of hours. I think most people have decided that's probably unlikely to be true, but it can be very cost effective. A case we did for Dyson a number of years ago was very, very efficient. There were very few letters between the parties. It was about a registered design. The question was just where the line is this too close to this or not? And it was very efficient all the way to trial. And the costs of that case were very, very low compared to anybody else. I don't think you can hear my doorbell. Sorry about that. Welcome to the podcast from home. The point is, you can do these things very efficiently, but it depends a little bit on both parties accepting there's just a legal question to be answered here, and also how the choices you make about how you then litigate it. It's also worth bearing in mind that lots and lots of these cases don't even get out of the starting blocks. I spend most of my days, it feels like, telling people how much it will cost to take a case all the way to trial, knowing damn well that as soon as we write the first letter or as soon as we issue the proceedings to make people aware of how serious the claimant is, they resolve themselves. They just need to believe it, because if obviously you're telling someone to take their product off the market, they're not going to do it if you just ask them nicely. You're going to have to make them realize that there's an expensive process if they don't. And of course, that can be terrifying for smaller companies. And so it's about the strategy you take on how you approach that through litigation or whatever to make people realize how serious you are. And of course, sometimes people will call your bluff, but most of the time they don't. And if there is a decent case there, they will realize that and they'll agree to do a redesign. And if everybody's relatively reasonable about it, it can be done quite cost effective.
So we've talked about some kind of abuses of designs, naughty takedown notices and all that kind of thing. And we talked about the commercial aspect where you're just trying to protect your Tower of Pisa shaped suitcase or whatever. There's a third one, which is quite dangerous, isn't it? Where people actually start taking your design quite every detail for counterfeit level purposes. And presumably when you get to that stage, the enforcement options open up even more. Is that right?
Well, I suppose by definition, if you're the closer the infringement is to your design, the easier it will be to get it taken off all the major platforms, and that is increasingly a major route to market for most people, including counterfeiters. So if you can get it taken off those platforms, then clearly that's good. There There are also obviously customs notices and things like that. You can record your designs at borders so that they don't come into the country in the first place. As with all sort of strategies dealing with counterfeits, you have to be careful how you do them. You're dealing with some nasty people who deal with these things. So it's all about intel. It's all about knowing where this stuff's coming from. We have our offices in China are constantly looking for, nipping this in the bud at source. And if you've got design protection, and maybe if you've got design protection, in more than one country, then that can help you to stop these things becoming a problem. The other thing we're seeing increasingly is some very effective online tools that enable you to take down infringing articles at scale in a way that you couldn't do in a cost-effective way manually. And we're developing our own system in relation to that, because it is the future of how to deal with this stuff. The one thing I would add, though, which is just a thing I think we need to watch, is I do think there's although I'm a big fan of takedowns, and a lot of my clients benefit hugely from them, I think we on a policy level need to be careful not to outsource our justice to private companies. I'm not suggesting they don't do it very, very well, but they are judge and jury of whether or not a product stays on a platform or not. And it's very hard to get an interim injunction in courts because it's such a powerful tool, and yet you can just file a takedown on a major platform, and that cuts off that route to market. So I think we as a nation have to think about that when we're doing these consultations.
So I'm the one charged with keeping an eye on the clock, and this is the easiest podcast to close down are the ones that naturally come to an end after about 45 minutes. The most difficult ones are the ones where you could just keep going forever, like this one, because I would happily sit here and talk to you for the rest of the day, but time doesn't allow us to do that. So it's always difficult to close down one where there's still lots to talk about. So recognising there's lots we could still talk about, but we've only got 4 or 5 minutes, I'm going to give each of you the opportunity just to say perhaps one thing that you thought that you would have the chance to say in the podcast, but you've not yet got across. So let's go, Will, Emily, John, Matt.
Okay, I think from my perspective, only because I focus more on the registration side of things, is that if you've got a design is not just the 3D shape, it's also the 2D surface decoration as well. So to use an example of a chair, if you want to register the protection for the chair, get the chair, but also if you've got any funky patterns on the chair, get those separately as well, because they can be just as important.
Okay, well, my one to mention that we haven't touched on really yet, or only very briefly, would be around design clearance. So the idea of, if you're going to launch a product, should you be worrying about the potential for infringing somebody else's designs? That is a potentially pretty big subject. So I think that's possibly something for a part 2 or a follow-up or something like that. But something to keep in mind, particularly if you're in a very sort of on-trend fashion-led industry where there might be lots of people doing the same thing at the same time as you. Something to keep in mind.
Absolutely. And I think the thing about designs, which maybe is, Lee, why this has been, we've rattled on without keeping much of an eye on the clock, and apologies for my part in that, is that designs are actually very complicated, which is one of the reasons the UK IPO is trying to simplify them. I think that they need to be careful how they simplify them, because there's danger in losing the good bits as well as the bad bits. But we spend a lot of time just guiding people through it. So do take advice. It doesn't have to cost lots of money. Lots of us design geeks are very happy to explain the system better. So much so that we've actually, as a firm, written a guide to designs, which you can download from our website. But it's a free guide that just gives people more information about how to protect designs and how to exploit them. I don't know, Lee, if you want me to tell you how to find it or
Yeah, go for it. Go on, John.
It's so our website is gowlingwlg.com. If you go /designs for life, there's a guide that you can download there. We've just updated it finally post Brexit, and it's got quite a lot of information in it, and I would encourage you to have a look at it.
Matt, have you got anything you want to sell?
No, I just thought, Lee, I think you described designs as being the sexy part of IP, and at the start of the podcast, and I just wanted to say that I think you're the first person to ever use the word sexy and IP in the same sentence.
So we always round up the podcast with a question that no one was expecting. I'm hoping this is going to go around about Christmas because we're halfway through December. So let's hope this one's going to land just before Christmas. So you four first, and then me and Gwilym. It's Christmas morning. What's the one present you're looking forward to unwrap? So in the same order, then, Will, you first. What are you desperate to find in your stocking?
Oh, I'm a massive fan of the London Underground. So if someone got me some Tube Maquette socks, I would be very, very happy with that.
Brilliant. Emily.
It's got to be a ride-on suitcase in the same shape of the Shard, right?
John.
Wow, I don't know what to say to that. I'm hoping to get some AirPods because I'm always the last person to get any new tech. And I'm very jealous of having all these cool headphones that drown out the train and all the announcements on the train. So if I can get some of them, that would be great. I'm not expecting them, but if they come, that would obviously be wonderful.
Matt.
I've already opened my Christmas stocking present because I bought my wife and I bought ourselves some new bedside lamps already for Christmas. So there we are. I'm afraid it's been very exciting.
Go on,
Baby sham.
what about you?
It's got to be the baby sham. You can't get it anywhere, but you've got to have baby sham in your stocking.
Baby sham.
Lee.
Oh, me. Well, me. Okay, so I've got a present just over there because it's my birthday tomorrow. So I get to unwrap stuff kind of midway through December, and I know because it's come from Scotland and my brother lives up in Scotland that it's a bottle of Lafroig. So I don't care what I get on Christmas morning because I would have finished that bottle of Lafroig and I'll be well happy. Oh, thank you so much for coming on the podcast with us. I'm sure there's a part 2 in this, so hopefully if we follow up in a couple of months or so, maybe you'll come back on and we'll pick up from where we left off, if that's okay. Thanks all.
Thanks very much.
Thanks very much.
Thanks.